so the first case I'm going to talk about, it is called McCluskey versus Kemp. This case got seen before the Supreme Court in 1987. Okay, so, oh my god, I almost feel like I'm like a true crime channel where it's like, guys, the case we're going to talk about today, blah, blah, blah. Okay, anyway. Alright, so in this case, McCluskey is a black man from the state of Georgia, and he committed a crime along with 3 other co-perpetrators where they robbed a furniture store. So, while robbing that store, a silent alarm was triggered and a police officer showed up to the scene. That police officer was then shot and killed. McCluskey and the co-perpetrators were then arrested. The co-perpetrators were offered plea deals by the prosecution. And I'm gonna take a quick time out there for a moment. I don't know all of the specifics about his McCluskey's criminal case, because this criminal case is not what was taken to the Supreme Court. The case that's taken to the Supreme Court is basically McCluskey alleging that he was discriminated against in the criminal case, okay? So just keep that in mind, but I want to explain a little bit about the criminal case first, because I think that gives us some good background information. But I don't know all of the specifics, like I didn't read, like, the case or whatever. Okay, so, back to his criminal case, okay. So, yeah, his co-perpetrators were offered plea deals, but he was not at his arraignment. I think that's what it's called, arraignment, I don't know. Anyway, at the one where he has to say if he pleads guilty or not guilty, he pled not guilty. The co-perpetrators testified in court that McCluskey was the most likely out of all of them to have shot the police officer, because I guess he was closest to the police officer, like, during the crime. So, to my understanding, they weren't saying, like, that they were, they witnessed McCluskey actually shooting the police officer. They just said, like, their testimony was simply that it would make sense that he was the one to kill the guy because he was the closest to the police officer, basically. Anyway, and there was also another testimony from a prison informant that said that McCluskey in jail, when they were jailed together, said, like, McCluskey basically, like, I don't want to say bragged, but, like, /confessed to killing the cop. The prison informant also said something about how, like, McCluskey said that, even if, like, 12 cops would have shown up to the scene, that he would have just tried to shoot his way out of it. And, in my opinion, what was the most damning evidence against McCluskey was the fact that the gun that the police officer was shot with was the same gun that McCluskey had robbed earlier. Like, he stole that gun. Now, again, I don't know the specifics on the criminal case, so I don't know if they mean it's the same gun as in it's the same model and whatever, or if that was the gun that shot the cop. I don't know. Anyway, so that was the trial. He was then found guilty and he was sentenced to death. Now, really quickly, again, I think it's good to have some background information about these things. So in order to get a death sentence, and I didn't look into this very much, so beware, but it's my understanding that a state needs to find aggravating, what is it called? Aggravating factors, I think. Yeah, I think aggravating factors. So, in his case specifically, the aggravating factors were that, he killed a cop in the line of duty, meaning, like, he killed a cop that was, like, on duty, I guess, say, for example, a state has the death penalty. That doesn't necessarily mean that you will, that a, what's the word I'm looking for? That the perpetrator or whatever will get a death sentence. In most instances, the prosecution has to find X amount of aggravating factors, and aggravating factors, there's already like a preset list. It's not like they're like making it up on the fly. There's a list. I think in some states premeditation is an example of a aggravating factor. I'm not sure as to how many aggravating factors you have to have in the state of Georgia, but at least for his case, he had two, and that was enough for them to sentence him to death. Okay, so once his sentencing is over, he's been sentenced, blah blah blah, he then basically files petition for habeas corpus. Listen, my understanding of habeas corpus is okay at best, but essentially my understanding of that is like an inmate could petition and say like, hey, my trial, I was not prosecuted correctly, that the prosecution basically violated his federal rights, is essentially what his argument is. So he takes his case first to another, like a higher court in the state of Georgia, so not like the county court that he was in originally for the criminal case. He he takes his case up to, like a court of appeals or something like that. I don't remember which one it was. But that's another thing that, like, to mention about Supreme Court cases, like, you can't just, like, take your case to the Supreme Court and, like, that's it. Like, it had to have been seen by lower courts first. So anyway, when he takes it to there, he claims, which, when I say he claims, I think it's important for us to remember to actually realize, like, he has legal representation, and his legal representation, it was some civil rights group. It might have been like the Legal Defense Fund or whatever that's called. I don't know. It was some like civil rights group, which I think it was the Legal Defense Fund. But anyway, okay. I'm trying to see exactly what his claim was. So basically, I couldn't find his like the claim, but basically he argues that there is a statistical study called the Baldus study that proves that the imposition of the death penalty in Georgia depended on some extent on the race of the victim and of the accused. He argues that his 8th and 14th Amendment rights were violated, and that the Baldus study will serve as evidence as to how he was discriminated against. So let's pause for a moment and let's break down a few things. So first, I want to explain what the Baldus study is. Okay, so the Baldus study, which is named after Professor David Baldus, who was its lead author, it found that defendants charged with killing white victims received the death penalty 11 times more often than defendants charged with killing black victims. And also Georgia prosecutors Georgia prosecutors sought the death penalty in 70% of cases involving black defendants and white victims, but only 19% of cases involving white defendants and black victims. The Baldus study was a very comprehensive study that looked at Georgia and how they do their death sentencing, I guess is what you could say. There's a lot of data, a is disproportionate, or sorry, the punishment is disproportionate to the crime. And he's also saying, like, look at all these other people that committed similar crimes and how they were not given the same punishment that I was. And the Balda study, what's the word I'm looking for? The Balda study kind of illustrates that, specifically for people who are, specifically for people who commit crimes where the, I guess like the victim's race is black, you could say, they are not as likely to get the death penalty as when the victim is white. So hopefully that makes sense why he was arguing that it violated his 8th Amendment rights. And then for the 14th Amendment, 14th Amendment is just equal protection under the laws for all individuals. So my understanding of the 14th Amendment, like him saying 14th and 8th Amendment right was being violated, was more so like my 8th Amendment right is being violated, which also violates my 14th Amendment right, because the 14th Amendment grants equal protections for all individuals. So he's saying, like, I'm not getting equal protection because they're violating my 8th Amendment. That's my understanding of as to why those two amendments were the ones that they're claiming are being violated. Okay, so let's run it back for a second. McCleskey, he gets what's the word like, right? He's found guilty, he gets sentenced to death, he petitions the courts, he's like, I don't think that this is correct, so he goes to like one appeals court, and I explained already his claim. He's claiming that he's claiming that the state of Georgia, you know, gives out the death penalty. Well, that's not how I should say. I'm going to read exactly. Okay, so like, his claim is that, like, I have this study that proves that when they give out the death penalty, it depends on the race of victim and the accused. And so that's what they're arguing, whatever, in the appeals court. And the appeals court does not find that his constitutional amendments were violated. Now, in terms of like whether or not the appeals court found that found the study was valid or not is kind of up for debate. But anyway, it doesn't matter. Okay, so he loses one of the cases. I can't remember how many times he like is fighting in like the lower courts, but eventually, let's just fast forward. Now he's in the Supreme Court. Okay. So in the Supreme Court, whenever the Supreme Court is hearing a case, they have to, there's just one question that they're answering, right? Like, typically, there might be, like, other things that are, like, wrong about the case, but, like, unless it's incredibly crazy and egregious, they're not going to, like, even, like, bother with that, they're just worrying about, okay, what is the question at hand? And so the question that the Supreme Court had to answer was, did the statistical study, which was the Balda study, did that study prove that McCleskey's sentence violated the 8th and 14th Amendments? That was it. Okay, so, explain that. Okay. So, their conclusion was that McCleskey could not prove purposeful or intentional discrimination, despite the fact that there was discriminatory effect on him. They could see that there was some type of discriminatory effect on him, I guess, but they could not find purposeful or intentional discrimination that existed in this particular trial, and thus there was no constitutional violation. So the justices are saying, well, despite the fact that the study itself shows discriminatory effect, meaning, like, we So that's basically unintentional discrimination. Disparate treatment is intentional harm based on race, sex, disability, or other prescribed motives. Okay, so they are arguing that the study didn't prove intentional discrimination. Now, I'm going to continue to talk a little bit more about the case, and then I'm going to jump back into something else. But let me not get ahead of myself. You know what I'm saying? Okay. So I'm going to read a little bit more about the opinion that the justices held, and this was like a 5-4 decision. So in my opinion, that's kind of like, I guess, a close decision, you could argue. But anyway, okay. So the things I'm going to read now are, some of this is verbatim from their opinion. Some of this is like just kind of like my rephrasing. I don't know which is which. I don't know. So, sorry. Okay. So the Balda study does not establish that the administration of the Georgia capital punishment system violates the Equal Protection Clause, which is the 14th Amendment. In order to prevail under this clause, the petitioner must prove that the decision makers in his case acted with discriminatory purpose. The petitioner offered no evidence of this specific to his case, and the Balda study is insufficient to support an inference that any of the decision makers in his case acted with discriminatory purpose. So basically, something that's important to understand is at this time in the Supreme Court, they basically do not allow people to litigate and claim that their constitutional rights were violated. More specifically, their constitutional rights as it relates to discrimination were violated if you cannot show intent. The Supreme Court has made it so that way you basically cannot litigate simply based on disparate impact. And if you do, and again, remember, disparate impact is just like unintentional discrimination. But if you do try to litigate for disparate impact, your evidence that you provide has to be like insane. Like, you have to show something that's like, okay, you know what I mean? Like, we get it. So like, an example would be like, if the Balda study showed that every single crime or every single murder where the accused was black and the victim was white ended up in a death sentence, that would be grounds. Like, that would be, my understanding is that would be enough for them to be like, yes, this is discrimination, despite the fact that you can't prove intent, because the evidence is so damning. Then they would be like, okay, yeah, that's discrimination. But that evidence does not exist. The evidence that exists is still damning. Remember, it was like 70% of the... I have to find it again, hold on. Okay, 70% of cases involving black defendants and white victims, prosecutors sought the death penalty, but only 19% of cases involving white defendants and black victims, prosecution sought the death penalty. Okay, so like, that's some serious evidence right there, but because it's not like literally 100% of cases, my understanding is like, that was still enough to argue. Okay, so anyway, like I was saying, Supreme Court is just like, Okay, so a little bit more information. Okay, so um in one of the cases, it wasn't at the Supreme Court, but like in the appeals case that they did, um the person who ran the study, Professor Baldus, he testified and said that we cannot say, because of course, you know, they ask him this, he says that we cannot say to a moral certainty that race influenced the decision for McCleskey, but basically the evidence, which is the Baldus study that was given, you know, the Supreme Court had to make an inferential decision, meaning like they had to use that information to then make an inference that, like, okay, yeah, more likely than not, the prosecution and the jury, you could say, made this decision based off of his race. Now, I can't remember if I said it already, but yesterday I listened to the actual oral arguments. Like for this case, I listened to the whole thing, and I remember something. Oh shit! Now I forgot. I remember. Let me see if I can remember. Okay, or I was gonna say now. One of the justices basically was like, you know, one way that, and this is not verbatim, of course, but one way, like, that the Baldus study could have provided more damning evidence would be if the prosecutor that was on McCleskey's case and the jurors that were on McCleskey's case were in the study, and they were shown in that study to have, you know, sought the death penalty more often for, you know, black on white crime, and also with that the same people that were part of his case also show how, in contrast, when it was white on black crime, they didn't look for the death penalty. Like, if they had that kind of evidence, then the Supreme Court would have been like, okay, they're a little more like, yeah, that evidence is a bit more damning, but because the evidence was separate from the people who were actually involved in his case, that was another big argument that the justices had as to how his argument or his claim failed. Okay, so continuing to read some of their opinion, or some whatever, the rest of their opinion or whatever. Okay, so one thing that they mentioned was that McCleskey's arguments are best presented to legislative bodies. It is not the responsibility or indeed the right of this court to determine the appropriate punishment for particular crimes. Legislators are better qualified to weigh and evaluate the results of statistical studies in terms of their own local conditions, with the flexibility of approach that is not available to the courts. Okay, so some things that I read from my book, or like the book I've been reading, was basically that, like, and also from listening to the justices during the oral arguments, it seems like they agreed that this evidence is pretty, like, damn, like, okay, like, we see what you guys are talking about. There is certainly a disparity yes, this the study is pretty. I think this study illustrates racial disparity. Now, whether that racial disparity is intentional is what the real question is, because if it's not intentional, well then the Supreme Court is like, we can't do anything about it, and also if it's not intentional, then it's not deliberately violating your rights. Your right to not be discriminated against. And yeah. So, like I read from their opinion, that this argument would have been better presented to like legislative bodies. The court argues that like they can't do anything about that. All they can do is answer this one question that's been put before them. They don't have the right to be like, oh my god, this disparity that's been shown is not okay, and so now we need to create legislation to make sure that doesn't happen. Like, they don't have that right as the judicial body. Anyway, and then another thing that they mentioned in their opinion is that differential result is not meaningful unless it's accompanied by discriminatory intent, which to me is just pure dog shit. Like, okay, I think so. Okay, let's think about that for a moment. I believe that you could think of what I just said there. The whole differential result is not meaningful unless it's accompanied by discriminatory intent, to mean that it's not meaningful in the eyes of the law. However, as a society, should we disregard that if we have information that shows that? Are we just saying, well, just you cannot prove they did that because of your color? You know what I mean? And one has to imagine, okay, but what does it look like? What does discriminatory intent look like in the eyes of the law? And in most cases, it's like legit, like it's just a fucking confession. Prosecutors like, yeah, you're right. I saw the death penalty because of his skin color. And they're not gonna do that. They're not gonna say that. However, from some things that I've read, like and I think I mentioned this already, you could use statistical evidence to argue, if you didn't have, like, a literal confession, so long as that statistical evidence is, like I mentioned earlier, like, insane, like, every single black person who kills a white person is given death penalty, but if it's any other race that's been killed other than a white person, like, they don't receive the death penalty or something like that, then yeah, like, then that evidence is way too damning. Another thing that was written in the opinion was something along the lines of, like, basically, and it goes back to the whole point I was making about, like, the Supreme Court sees that this evidence, that the statistical study is persuasive, I guess you could say, but they had to make the determination as to whether or not it was persuasive enough where they see that it's constitutionally unacceptable. In their opinion, one of them argues, and I want to say it might have been Sandra Day O'Connor, Justice Sandra Day O'Connor. She argues something along the lines of, like, racial disparity and discrimination is bound to happen in our court system, but like, in this case, what's happening in Georgia, that's constitutionally acceptable, because no matter what, we're gonna have some type of discrimination, so it's not enough discrimination for us to do something about it. like I said before, like, some of this is verbatim, straight from it, some of it is paraphrased. I don't know which is which, whatever. Okay. The dissent claims that the discretion afforded prosecutors and jurors in the Georgia capital sentencing system violates the Constitution by creating opportunities for racial considerations to influence criminal proceedings. Let's pause there for a moment. So, let me see how I can explain this. So, one way that McCleskey could have argued or possibly tried to find discriminatory intent would have been if he was able to get information straight from the jurors from his case, and also information straight from the prosecutor's office from his from his case, whatever. But I suppose Georgia has a lot of discretionary laws where, like, you can't do that, you can't request things like that. That's my understanding, I don't know for sure. And with that being said, they basically now my cat's trying to leave. She can't be pleased. Okay. So when the dissent claims that the discretion that prosecutors and jurors have in the state of Georgia for like their capital sentencing system, that within itself violates the Constitution, because it's creating opportunities for racial considerations. Like, it's creating opportunities for people to use race as a basis for sentencing, and basically it's like, you could think of it as like, these people can do whatever they want, and we can't find out what they're doing because of the discretion. So, like, we have no way of, if there wasn't so much discretion involved, then I suppose what this justice is arguing is that would be a way to mitigate any racial considerations that is happening. Okay. Moving on, continuing with their dissent. The Baldus study indicates that more likely than not, the jury would have spared McCleskey's life had the victim been black. The statistical evidence thus relentlessly shows the risk that McCleskey's sentence was influenced by. It shows the risk that McCleskey's sentence was influenced by racial considerations. Close analysis of the Baldus study in light of both statistical principles and human experience reveals that the risk that race influenced McCleskey's sentence is intolerable by any imaginable standard. So basically, they're saying, like, okay, well, the evidence is showing us that, like, yeah, the evidence is proving to us that if the victim was black, he wouldn't have gotten the death penalty. So yeah, one thing that I remember the defendant, which is the state of Georgia in this case, arguing was that they said that, like, the white cases of murder, so like basically like white accused black victim cases, were so unique and different than the cases that involved a black accused and white victim, and even cases that involved a white victim and white accused. And so, like, that was another reason why the state of Georgia, this attorney was arguing that, like, the case is invalid because you can't even compare them in general, because there are different circumstances that are so incredibly different. Whatever. Okay, so, and kind of give a little more information about McCleskey. So, as we now know, the Supreme Court case was lost, and they ruled in favor of discriminatory law, you really, really, really needed to show discriminatory intent, because even with evidence like this, the BALD study that was incredibly comprehensive, very meticulous, it used multiple regression analysis. By the way, I don't know what the fuck multiple regression analysis is, but they kept bringing that up, so I was like, that must be a good thing, I don't know. Even with that, it was not enough for the Supreme Court to say, like, yeah, evidence like that is enough for us, even without you providing evidence of discriminatory intent. And so it, in a lot of ways, kind of closed the door for other cases, basically, because they had a crazy ass study that showed discriminatory effect, and inferentially you could say, like, well, you know, there was some type of discriminatory intent, because we're showing, like, it's just happening so often, and they're saying, like, no, it's not enough. Then, you know, what chance do other people have, you know, to fight for their, to fight for their right? You know, like, most people don't have a professor who's gonna be conducting all this, be conducting a study on your behalf to get this information. And even when you do have that, it's not enough. So yeah, even with multiple regression analysis, you cannot prove unfair or discriminatory treatment. Gross racial disparities do not merit strict scrutiny in absence of evidence of explicit race discrimination, evidence of which is nearly impossible to obtain. So gross racial disparities, my understanding of that is, like, with the naked eye, we can see that there are racial disparities. So when I read those statistics to you, you don't need to analyze it anymore. That was, you saw, you understood, yeah, that's a racial disparity there. But even with that, it doesn't merit strict scrutiny. It doesn't merit, like, we really gotta look into that, you guys. Because there is no evidence of explicit race discrimination, meaning prosecutions coming right out with it and being like, yeah, I was being discriminatory based on race. And again, that evidence is almost impossible to attain, and as mentioned in the dissent, it's almost impossible to attain in the state of Georgia at this time. Who knows? This is in the 80s, in the late 80s, so, like, things could have changed, I don't know. But because of the discretionary laws that are allowed to them, is that the right way to say that? Whatever. Okay. So that was our first case. McCluskey versus Kemp. And, something else I want to mention is just, well, I guess, I don't know, like, big picture from this case in my mind is just like, okay, Supreme Court means business when they say you have to show discriminatory intent. Now this next case is something very similar, kind of. Oh my god, wait, you guys, I totally forgot I had another page of notes, so I'm just gonna read some more from here. Wait, actually, before I do that, I want to mention, okay, so like I said, this whole case, McCluskey versus Kemp, was like, yeah, you need to show discriminatory intent. And this next case I'm going to talk about is also the same thing, discriminatory intent. You have to have that. It got me thinking about, like, okay, when the hell, because here's the thing, when we're looking at, let's talk about specifically, the 14th Amendment, it doesn't say there that you have to have intentional discrimination in order for a citizen to have, like, private right of action, meaning, like, a citizen could sue and say, like, their rights are being violated. It doesn't say that it has to be intentional or unintentional. It doesn't say that. But something that's very important about the Supreme Court is they interpret the law So, like, that's why all these cases are so important, because they inform each other. They inform the way that these justices are then supposed to apply the law, interpret the law. It's just very fascinating to me. Okay. Okay. All right, and then finally, so when I read the opinion to you, I mainly focused on the fact that, like, the 14th Amendment, or like, did the study show that he was violated against specifically in relation to the 14th Amendment, is how I was taking that. Now, in terms of the 8th Amendment, because remember, he alleged that his 14th and 8th Amendments were violated. They said that the 8th Amendment was not violated unless the state sentences defendants to death in a manner that is completely arbitrary and lacking in reason. So, like, you could argue that if you found the way that they were sentencing people to death was very arbitrary, that yes, it was disproportionate then. But they looked at the way that they sentenced it and they were like, we can't see that it's arbitrary or lacking in reason. Which one, I guess, could argue, like, looking at the data, could you not say that it's arbitrary and lacking in true reason that that 70 was it 70% of the time, if it's a white victim and black accused, they're gonna get the death penalty, as opposed to 19% of the time, if it's a white accused and a black victim, they're getting the death penalty only 19% of the time. But anyway, and then last thing I'm gonna read from this is, so this was actually something that I heard in the oral argument. The attorney's name, who was like the attorney for the McCleskey side, Boger is his name. So, okay, I'm just gonna read what I wrote. Attorney Boger argues when asked by Justice O'Connor, how does the study support the claim of discrimination against the defendant? So he says, if Georgia had a statute that made killing a white person a more serious crime, then they'd, meaning, like, I guess people, the general public, or the state of Georgia, they'd say that's unconstitutional and an invidious discrimination. If Georgia is administering its statutes in precisely that way so that those who murder whites are subject to more severe risk of death, then I believe the situation is identical. So my understanding of that argument is basically like, if Georgia straight up had a statute that was like, yeah, if you kill a white person, you're done. You know, you're more likely than not gonna get the death sentence. That would be, we would all be like, yes, that's discrimination. But in this instance, there is no statute that says that. But if Georgia is using their neutral statute in a way that elicits the same result as if they did have a statute then like that, then it's essentially identical in his mind. So I thought that was a really important thing. I think that argument was very good, especially in the whole dispute of, like, well, there's no, there's no intentional evidence. There's no evidence of intentional discrimination. That reminds me of something from, so, like, again, he's arguing, like, okay, but if you're using this neutral law in a way that is affecting, a specific racial demographic, then it's basically the same thing. Okay, that made me think of something from the book, and I wonder if they made that connection already, and that's why I'm thinking of it. Okay, well, let's see. God, I'm like out of breath. It's insane. I get so hyped when I'm talking about this stuff. Gosh darn it. Okay, yeah, here it itself be fair on its face and impartial in appearance. Yet, if it is applied and administered by public authority with an evil eye and an unequal hand so as practically to make unjust and illegal discriminations between persons in similar circumstances, the denial of equal justice is still within the prohibition of the Constitution. Period. Right? I feel like that kind of goes together. Okay, anyway. Now I'm done with McCluskey. I have nothing else to say. I have exhausted all that I can say about the McCluskey case, and I think I already talked about big picture. It makes it harder for people to litigate discrimination, especially when you are lacking intentional discrimination evidence, whatever. Okay, let's jump into the next case. Alright, this one. Let me catch my breath, hold on, y'all. Okay, so for this case, it is Alexander v. Sandoval. This case was brought to the Supreme Court in 2001. Sir. Okay, background information for this case. Again, like I said, both cases I'm talking about, so even for this one, we're still thinking about that whole disparate impact versus disparate treatment. So disparate impact meaning unintentional discrimination, and disparate treatment, intentional discrimination. We're still having those things in our mind. Okay, so anyway, so the story of this case goes that there was a Mexican woman who lived in the state of Alabama, and this place originally takes place in the late 90s, like the civil suit part of it, I guess, takes place in the late 90s, and during this time, Alabama had added to its constitution or made it a law, I don't know, something like that, where the official language of Alabama was English. And so with that adoption or whatever, the DMV then made it so that driver's license tests were only available in English. And so of course this affected many people who either A, don't speak English, or B, can't, don't speak English that well. Because in my mind, there's a different, some people can have a conversation with you, to the best of their ability, and you can somewhat get by, but it's a totally different thing when it comes to having to try to read and literally take a whole ass test. You know what I mean? I don't know. I'm not gonna get hung up on this idea. Anyway, okay. But hopefully you understand what I mean. Some people, conversationally, you can try to speak in a different language, but, to take a test in that language would be a totally different thing. So, I feel like it affects not just those who literally cannot speak the language, but also those who, have limited proficiency in that language. Moving on. So, there's another civil rights group. I think it was the Southern Poverty Law, something. Yeah, Southern Poverty Law Center. So on her behalf, they sue the Department of Public Safety in Alabama for discrimination. The claim that they make is this. They claim that English-only driver's tests violated the disparate impact regulations enacted under Section 602 of Title VI of the Civil Rights Act by discriminating against them based on the basis of their national origin. So much in there. First, the claim says in there that it violated the disparate impact. Let's remember, disparate impact is unintentional harm caused when there is a seemingly neutral policy enacted, passed, whatever. They also mention that her Title VI rights were discriminated against. So let's jump in for a moment here before we continue talking about this case as to what on God's Yeah, so it empowers federal agencies to enforce the Title VI's ban on discrimination. It also authorizes and directs federal agencies to create rules that comply with Title VI, and making sure that they have policies, regulations that ensure that there is no discrimination. Section 602 also gives agencies the power to terminate, cut off federal funding from, like, to cut off federal funding if they are found to be in violation, and that can only be done after a hearing, which that was something that was said in the actual whatever. Okay, that seems like really crazy. Okay, let me get back to this. So anyway, recap. A lady wants to take her driver's license test in the state of Alabama. She can, because the state of Alabama now only offers English only tests. So this the Southern Poverty Law Group, or Southern Poverty Law Center, takes her case, goes and sues the Public Safety Department, or Department of Public Safety, and alleges or claims that they are violating her Title VI rights. Her Title VI rights, and they say that they violated the disparate impact regulations enacted under Section 602 of Title VI by discriminating against them based on basis of their national origin. And I just read to you what in God's green earth is Title VI, and again, Title VI is that no person in the United States should be discriminated against for color, race, or national origin from a institution, we could say, that receives federal assistance. And they're saying specifically under this. Now this is where I get lost, truthfully. And they're saying that specifically under Section 602. Well, actually, let's not even get into that because I'm still a little confused about that. Okay, anyway, moving on. So, they sue and they win. Alabama then takes back English only tests, and at that point in time, they offer the driver's license tests in 7 different languages. Apparently, today now it's offered in 10 different languages in Alabama. So, when they win that case, the state of Alabama is like, we don't like this, we're pissed off about this, and so we are going to appeal. And they appeal on the grounds, not that, like, well, we don't agree with the judgment, we didn't violate any rights. They appeal on the grounds that this private citizen does not have the right to sue us under Section 602 of Title VI. That's what they say. That's that they're claiming. Now I can't remember. Let me see. Do I even have it there? Let me read this really quickly. Alright, let me see where it was. Okay, blah 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 So this case gets seen at the Supreme Court. Let's get into how that went. So, the question that the Supreme Court has to answer is simply, can private individuals sue to enforce disparate impacts under Title VI? Wait, let me see if I wrote down, like, some of the arguments that they made. Okay, before I get into the conclusion. In this case, the petitioner is the state of Alabama. The defendant is, Sandoval, which is the lady. Like, again, it's not literally her arguing, it's her attorneys. So it's the Southern Poverty Law Center or whatever that was arguing this case. And so the attorney representing Alexander, or like the state of Alabama, you could say, they argue that there are several indications in Title VI that Congress did not mean to imply the creation of a private right to action under the 602 regulations. Now, this case, more so than the other case, this shit gets deep. So let's take a moment to talk about this, okay? So, one thing I want to bring up and kind of discuss briefly, in this case specifically, and also in another case that they cite, or they reference, I guess you could say, there is this issue, I guess you could say, that the Supreme Court constantly has to grapple with, which is they have to read a law and interpret what Congress implied by said law. In this case, the justices need to interpret whether or not Congress implied that private citizens could sue or seek litigation, whatever, I don't know how you would say that, under Section 602 of Title VI. And it was very funny to listen to the oral arguments and also to listen to how the justices kind of like explained their thinking or questioned, the attorneys, because it just seemed to me very silly for them to be like, well, when I read it, this is what I think. Well, when I read it, this is what I think. Motherfucker, Congress is in the same city as you. Like, to me, it seems so, like, nonsensical, I guess, that you could just be like, a lot of those fuckers are still in Congress. Let's go ask them, what did you guys imply by this? And I was thinking about it a little bit more, like, especially if it's a statute, a bill, whatever. Like, we can't just ask the people who wrote it, what did you guys mean by this? We have to, like, have 9 motherfuckers come up with whether or not, something is right, you know what I mean? Or come up with, like, what their understanding of said statute or act is. It's just, again, to me, very silly, but I think that maybe a reason why we don't do that, or why that's not something that's done, is because then that would provide Congress with a lot of power, because then maybe because, they make the law, and now they also get to interpret how it should be administered, and maybe that's, like, too much power for Congress to have. But, right, like, I don't know, I kept thinking of that as I was listening to this. I was just like, what, like, literally, like, we're over here, like, what did he mean by this? I let's do a little tangent here. This Supreme Court case happened in 1979. In this case, there was a woman who was, I think it's gonna start thundering, you guys, so sorry ahead of time. There was a woman who was 39 years old and she was applying to med school. She applied to Northwestern University and also to the University of Chicago. She was denied or rejected, whatever, from both schools. It was a little fishy to her that some of her classmates who were less qualified than she was on many levels were admitted, but she was not. She gets information at some point that University of Chicago, and I don't remember which is which, like which policy goes to which one, but one school doesn't admit anyone under or over the age of 30. The other school doesn't admit anyone over the age of 35 without an advanced degree. She claims that this was discriminatory against women because women more often than not have to, go to med school later in life because they have families to raise or kids to have, whatever. And so she sues under Title IX. Now, Title IX of the Civil Rights Act, I hope I'm saying that right. Yeah, Title IX of the Civil Rights Act is exactly more or less what Title VI says, except in this case it's not discrimination against race, color, or national origin, it's discrimination against sex. Another special thing that's in Title IX is that it also relates to educational institutions, so not just federally funded places or places that receive federal assistance. It can also apply to educational institutions, which is why she was able to sue University of Chicago despite the fact that they're a private university. I don't know, I could be wrong about that. Okay, anyway, so she tries suing a bunch of times. She keeps losing on two grounds. One ground is they say that she cannot prove discrimination, and the second ground is that they say she doesn't even have a right to private action, meaning she doesn't have the right as a private citizen to sue or to pursue litigation under Title IX. Some time passes randomly. Congress passes a act, I think it was called like the Attorney's Fees Act, and it was basically about how, like, if you sue under Title VI, under Title whatever, like these different titles, was a test that they had used previously to kind of say, like, well, do we think that Congress implied private rights action? They basically, do the same questioning. I don't know how else to explain that. And they come to the conclusion that yes, under Title IX, she does have private right to action. Excuse me. So, keep in mind, this woman who wants to sue for discrimination, her claims or her evidence is that these two schools are not admitting people past the age of 30, and that disproportionately is affecting women. Okay, keep that in mind. Keep that in mind, because we're gonna come back to that. Okay, sorry, that tangent is important, I promise. Now let's go back to the Sandoval case. Again, this time it's the state saying, wait a goddamn minute, you guys don't have the right to legally, you guys don't have the right to private action under Section 602, because that was the original claim from Sandoval, was that under Section 602 they're discriminating against her. Okay, so now let's get into what was the conclusion now that was made. So in a decision 5-4, this is the conclusion. There is no private right of action to enforce disparate impact regulations promulgated. Title VI itself directly reaches only instances of intentional discrimination. Neither in its original writing nor as later amended does Title VI display an intent to create freestanding private right of action to enforce regulations promulgated under Section 602. Supreme Court basically is like, yeah, under Section 602 it does not, to us the justices, appear that there is a private right of action. Also, there is no private right of action in order to enforce the disparate impact regulations, being to enforce I think of it this way, this is the way that I think of it, to enforce that these agencies not participate in disparate impact, right? So not participate in creating neutral laws that disproportionately affect a demographic. Oh my god, I'm like out of breath from explaining this. Okay, anyway. Furthermore, Section 602 specifies that the federal government could cut off funding. Right, like when I read you that crazy ass shit, right? Okay, it specified in there that the federal government could cut off funding, with that language expressly provided within the statute. It also expressly provides only one method of enforcing those regulations, of which none are private right to action. So the attorney for Alexander had argued this, and then in the opinion, Scalia kind of like reiterated that, like, okay, well, there's already a process in place in Section 602, which that the federal government would enforce these regulations, not a private citizen. Okay, I think I finally understand what enforce regulation, or enforce whatever it means. I think it is enforce that they have to do that thing. Okay, anyway. Continuing. was literally told I didn't even have a right to do this, and now Congress is saying, like, you can get legal fees paid. So she takes it all the way up to the Supreme Court. The Supreme Court has to answer whether or not there is a private right to action in Title IX. Okay, and they say yes. So why would they bring up or reference this case, University versus Chicago, and this current Alexander v. Sandoval case? I mean, it looks similar to me, right? The argument is just within this title, is there private right to action? That's it. That's what they have to answer, okay? So that's why they keep bringing it up. In that case, right, they argue in University versus Chicago, the Supreme Court found that there was a private right to action. But because, now this is like, okay, I was gonna read, okay, but because the majority, meaning like the majority during the Sandoval case, like the majority of the justices found that her claims were more, I guess, intentional discrimination because of a footnote in the case that said that she was discriminated against, or that they discriminated against women. My understanding of that is basically like perhaps they actually, we'll get back into that. Okay, whatever. Okay, let me back it up. Justice Stevens is like, wait a goddamn minute. We literally told this woman back in '79 that she had a right to private action. Mind you, her claim was based off of, it was disparate impact, okay? He, in his mind, is like, that was disparate impact. However, the majority of the justices, in their minds, because of a footnote that was found in that case, in the Cannon case, it said something along the lines of discriminated against women. I suppose they found that it was intentional discrimination, but Justice Stevens is like, that wasn't intentional discrimination, and we ruled in favor of her, saying she had private right to action. This case where there is a rule that is neutral, but it's affecting a demographic, we're saying you can't because it's disparate impact. But that other goddamn case was also disparate impact, and we allowed it. Right? Like, that's, to me, also not making sense. Okay. So, however, Justice Stevens claims that it was a disparate impact claim that Cannon had. But the court, during that Cannon case, they never decided whether it was intentional or unintentional discrimination. They just decided simply if she had private right to action. She won that case because of Title VI, which I explained already. She was like, these acts or whatever or these titles, whatever the fuck, they're the same. Why can't I also have the right for private action? Blah blah blah. Okay, but the thing is that, skipping past that, okay. Stevens further argues that the interpretation of Title VI and this idea that Congress did not intend for private citizens to sue is flawed. He says regulations authorized in Section 602 must be designed to protect precisely the same people in Section 601, meaning the private citizen. So he's saying, how can we say that there's a private right to action in Section 601 but not in Section 602? One could imply that all of it remains the same. It's all in the same title. It should all, protect or afford protections to the same people. That's his argument. Now, okay, this case gets me fucked up because, like, in my mind, it was more so because at this point in time, there was no precedent set when it came to having private right of action for Title IX, and I think that they were kind of just like, yeah, fuck it, let's just do it, you know what I mean? But today, like for Title IX, it's the same shit. You have to prove intentional discrimination. You cannot do a disparate impact claim. So, but because they were not, looking at what kind of discrimination took place, they were only looking at whether or not private right of action was implied within the title by Congress. That's, you know, like that's what drives me crazy, because it's like I mentioned at some point in this long ass video, that the Supreme Court only looks at one part of a question. That's it. But in my mind, like, and again, I could be wrong, because there's another aspect here that's important, and something that was harped on by the plaintiff, which is that a private citizen specifically does not have the right to enforce the regulations or whatever the hell. That was the point they were really sticking to. The disparate impact thing was kind of also talked about slightly, but it was really, they were hitting that point. They don't have the right to enforce that. They don't have the right to enforce that. There's already an apparatus set up, which is within Section 602, that says that the government does something about it, right? Okay. But in my mind, with them saying, no, you have no right to private action, then that bitch, no offense to the canon lady, but that bitch also had no private right to action, because it's the same thing if they're, you know, like it's a disparate impact claim. Anyway, okay, I don't know, I'm kind of done talking about that one too, because I feel like I'm just talking in circles. Anyway, I think I read everything. From this, yeah. Okay, now, to bring it all back, how did this case affect, discriminatory laws, anti-discrimination laws, and whether or not people can, I guess, litigate. So this case furthers this idea that you cannot litigate discrimination that is deemed as a disparate impact, since that is not what Title VI refers to as discrimination. They only, well, I shouldn't even say refer, imply, because there's no reference to it in the title. It's just simply what the courts have implied. Anyway, okay, so the Supreme Court holds in Sandoval v. Alexander that private citizens have no right to action in cases of disparate impact, only intentional discrimination. And I guess another way to interpret this would also just be simply that private citizens don't have the right to litigate in order to enforce these protections. Because, like I said, that was a point that they were really, the Alexander side was really arguing. So it just again creates this problem where you can't do shit. Like, you can think of it that way. Because, I mean, like, I was thinking about it myself. If you are a federal government agency and you say we only offer services in English, you can only do this in English or whatever, yes, there is a disparate impact. There is going to affect specifically a group of people, and you can't do anything about it legally. You can't. And that is just pretty crazy to me. So anyway, my god, this is such a long ass video. Thanks for